Welcome to our Rapid Fire Wednesday Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in San Diego, and I'm joined today with the co-managing partner of WR Immigration's Boston office, Miki Matrician. Hey to you, Miki. How's everything going?
Going well. Hi, Kimberly. So I'll start us off. For today's installment of our Rapid Fire Wednesdays, we want to handle questions about the use of clawback provisions to use as an incentive for employees to stay with the company after they've been sponsored for permanent residence. Actually, let's step back a bit and set the stage a little bit. So let's say the company is Acme Company employing an awesome employee pursuant to H-1B status. She started with the company right out of college and has been progressing in her career as an engineer. Let's say her manager reached out to the HR immigration team to initiate the process to sponsor that employee for permanent resident status or the green card. And the process is going to have multiple steps and span over several years. Unfortunately, it takes a long time. And the manager wants desperately for this employee to stay with the company for at least a few years, and preferably after becoming a green card holder too. Part of it is because it's such a huge investment in time and money and effort from the employer side.
Yeah, it is definitely time consuming, right? So, Miki, we could actually take an entire Rapid Fire Wednesday and maybe even a whole month of Rapid Fire Wednesdays to discuss the green card process. So today we're not going to bore everybody with that, but in order to provide a little bit of context to HR professionals, hiring managers, and employees, would you mind giving us a little bit of an overview of the general steps for the permanent resident process for most professionals?
Sure, I'll try to keep it kind of canned and short and sweet. So, in most situations, our global mobility partners are going to go through the three-step process to sponsor a foreign national employee for a green card case. So, that means that the first step is the employer dealing with the U.S. Department of Labor's PERM, labor certification process. And in that first step, the employer is required to prove that there are no willing, available, and qualified U.S. workers by doing a recruitment campaign for that position. That's the test of the labor market. And once the Department of Labor can certify that the employer has performed the required recruitment steps and didn't find a qualified U.S. worker, then the second step is to file what's called the I-140 immigrant visa petition. And that's filed with the immigration services. And then finally, if the green card number becomes available, the third step is the foreign national employee's personal application to the immigration services to confirm, yes, I do want to become a permanent resident based on that employer sponsorship.
Okay. So you talked about three steps, and with the first one being the test of labor market, which seems really burdensome. Do employers have to go through this three-step process for all employees if they want to sponsor someone for permanent resident process? Or is there possibly a shorter way around to getting a green card?
There can be a shorter way to kind of bypass that perm labor certification test of the labor market process, but not always. In some cases, planning together with counsel and analyzing, global mobility professionals can determine that an individual may qualify for one of the two-step processes, which bypasses the Department of Labor. So those are categories for people who have extraordinary ability, people who are outstanding researchers that meet the criteria, multinational managers, and national interest waivers.
Okay. So, Miki, you mentioned that, with the two-step process being potentially a little bit shorter than the three-step process where there's a test of the labor market. You also mentioned that we should note for HR professionals that it can be a really lengthy process. So, without using your crystal ball, or maybe with using your crystal ball, what is the typical processing time from beginning to end for the permanent resident process?
Well, unfortunately, a while. Not quick enough for HR immigration professionals, and definitely not quick enough for the foreign nationals that are being sponsored. It's primarily, the government processing times, but also the employee's country of birth, because that determines which queue for green card number they go in. For the processes that are exempt from perm, it can still take a couple of years because the USCIS is slow. And then for perm based processes, that does involve that test of the labor market. Just the perm itself can take about 2 years from start to finish until you get that Department of Labor certification. And then from beginning to end until the green card is issued, it can take, 3 to 5+ years, not factoring in any of the backlog of green card numbers. So it's a long time.
Okay. So with that really lengthy process, I mean, even a few years is really long, when people are wanting to get that green card. So, Miki, does that mean that given this lengthy process, do the foreign national employees have to remain with their sponsoring employer all the way to the end of when they are actually approved for their green card?
Yeah, depending on the case, yes. And it is a long time for a lot of individuals, especially because the green card case is specific to the employer in most cases and to the position and the location. So it is a long wait. Essentially, foreign national employee does need to stay with the sponsoring employer throughout the whole process once that process has been started. And if they want to finish that process with an employer, obviously, there are portability provisions in the law that permits a foreign national employee to change employers and not have to start the green card process all over again. If the foreign national has an approved I-140 immigrant visa petition and the I-485 adjustment of status application has been pending with the USCIS for at least 180 days, then they can port their green card to a new employer so long as they're continuing to work for substantially similar position for which the perm was initially sponsored. So if a foreign national employee leaves the sponsoring employer before that 180 days is met, the employer has to start the process all over again. If the I-140 has been approved and then the I-485 adjustment of status hasn't been pending for 180 days, the employee can keep their priority date when they leave that sponsoring employer. That priority date is their place in the queue for a green card number. But then a new employer would have to do a new perm and I-140 for that new employee. They do get to continue to progress in the queue until a new case is finished.
Okay. So, Mickey, it sounds like employers are making a financial investment, but they're also making an investment of time in their, employee, right? So if they find someone that's a fantastic employee, they want to keep them on board, they have to go through these hoops, right? So HR is for the perm labor cert process, they're conducting a test of the labor market, which, is a lengthy process and it's a difficult process to go through, right? It's very stressful for anyone. We're also looking at the individuals who are contributing to the company, right? If they're really good workers, they're the part of the support team that is making this company one of the best companies, right? Or actually producing that product or providing that service. So the employee is very valuable as well. And the employer is also spending time with professional development as someone is moving forward with their career and trying to make a life here in the US. So it almost seems natural for an employer to want an individual to stay with the company through this green card process because it is an investment of time, it's a financial investment as well. And one of the questions that we get a lot is with respect to incentivizing sponsored foreign national employees to stay with the company. Can the employers have some type of agreement with individuals in which they can have the employee have a stake in this process, right? A financial investment in this process so that they will want to stay with the employer, until they get their green card process or at least for a significant period of time. So is that doable? Can employers, prepare some type of an agreement like that?
Yeah, certainly completely understandable for companies to want to, get the employees on board and kind of, as you say, have a skin in the game. Government regulations do require that all costs and fees for the perm labor certification be paid for by the employer. It's in fact, the regulations explicitly prohibit the cost being shifted to employees. So companies can't have employees pay for any part of that perm process. And that's really important. And it's part of the application attestation that employers make that they are covering all of the costs. And so that means, attorney's fees, advertisement costs, all of that. And it's tough too because the required Sunday ads that are part of the test of the labor market can get pretty costly, especially in California or New York. And in terms of the remaining steps for the green card case, the same restrictions don't apply. So for the I-140 immigrant visa petition, or the third step of the process, which is the I-485 adjustment of status for the consular immigrant visa application, there's not such a restriction. So it is okay from a legal perspective to shift those costs onto the employee.
Okay. So if an employer can have an agreement with a foreign national employee to pay back costs for the permanent resident process, excluding, as you said, the perm labor certification application process, we get the question from HR professionals, well, what does that agreement look like? What is typically involved in it? Do employers want to have employees pay for or not pay for?
Yeah. So if there's any agreement like that between the company and the employee, we recommend to HR partners that they have an agreement from the very beginning of the permanent residence process so that all parties are on the same page. I would recommend that the employer specifically state as part of the repayment agreement that the employer will bear all of the perm costs, including the attorney's fees and recruitment costs, so that that can foreclose and prevent any claims in the future. And of course, best practice would be to memorialize this in an immigration sponsorship policy as well, so that employees' expectations can be managed right from the outset of their immigration journey with the company. One issue that sometimes employers forget about is that it is important that any agreement should be applied consistently so as to avoid potential discrimination claims. So, for example, if an employer treats certain groups of people differently than others, or making exceptions for national employees where different treatment is applied to US citizen workers, the US workers, that could be a problem. They could be opening themselves up for discrimination liability. So, if you find that circumstances warrant making an exception, I would recommend you talk to your employment counsel on the potential discrimination issues. And then, in terms of what does it look like in terms of how to structure the repayment agreements, a lot of it does depend on the company culture and the size of the organization and how aggressively the company needs to recruit and retain the foreign national talent. The model that I've seen a lot of larger companies use, in the most competitive talent market is basically that the company pays for all of the costs and fees for all steps of the green card process, including for dependent family members. I have seen some companies have carve outs where maybe they don't pay for certain aspects or certain parts of the dependent family's costs. For example, EADs, now that there's new fees associated as of April 1st for specifically for EADs that used to be covered by the I-485 fee. So examples like that, or not covering H-4 EADs on the non-immigrant employment authorization side. I do think in the current trend, I think, is that some larger companies have changed their policies to not cover dependent costs. And so, for dependents, one option could be to decide on a menu of options that the company will cover and what it won't cover and publish it in the immigration sponsorship policy. And another that I've seen is to cover up to a certain dollar amount for dependents, and they would be responsible for any additional costs or fees above that threshold.
Okay. So I've also seen companies structure it where the employee is responsible for the fees and costs associated with the I-140 immigrant visa petition, as well as the I-45 application to adjust status. And then it's structured in a way that if the employee remains with the company for at least 1 year after becoming a permanent resident, the employer will reimburse that individual. And there can also be steps, right? Sometimes if you remain for 6 months, we'll reimburse 50%. If it's for a year, it's the full amount. However, it does get really tricky when you're dealing with individuals who are subject to significant quota backlogs, right? So individuals who have been born in India or mainland China, they might be looking at a backlog of 5, 6, 7, 10+ years, and which means that they're not going to get their green card for a really long time and requiring that they remain with the company for at least 1 year after that period of time for any kind of reimbursement. In this case, it might just be the I-140 petition. Doesn't seem to be very equitable, right, in terms of what other employees might receive in terms of reimbursement. So some of our companies structure it in a way that if an employee remains with the company for at least 2 years after the start of the green card process or after the filing of an I-140 petition, there's so many different ways to structure it so that it can be pretty consistent with all employees and not one is being penalized over the fact that they were born in a country with significant quota backlogs. So it gives employers a lot of creativity and how they want to structure this and what's best for the company as well as for their employees. And, while there are various ways to structure these agreements, we also recommend that, our HR professionals, run the agreement by an employment law attorney in the beginning when it's being structured to make sure that that repayment is stated in a way that an employer can actually enforce it. So as immigration attorneys, we kind of know what's going on, but we always want to make sure that it is a valid, enforceable in a particular state in which the company is located or the employee is located from a worksite perspective. Because while we're immigration attorneys, the immigration law and how to structure some of these things. But employment law can always be a little bit tricky, especially when you're dealing with payroll and clawbacks and all that kind of provision. So we just would, recommend doing that and, having a good agreement in place.
Yeah, and Kimberly, you mentioned the scenario where the employer has the employee pay for everything up front and then reimburses at the time that the employee kind of completes certain periods of months of service or certain years of service. I've also seen employers include a repayment provision where the employee would reimburse the company if they left within a certain period of time. But I think that the scenario that you mentioned is probably administratively easier for the employer to manage.
Yeah, it just all depends. All right. So, as we are on the topic of recouping payments, right, employers often get confused about what is permissible in the non immigrant space. So, for H-1B petitions and with respect to that context. So, while we're talking about agreements and recouping expenses, Miki, can you talk about what employers can recoup when it comes to the H-1B process?
Thanks for raising that topic, Kimberly. I think it's important. For starters, the regulations say that the employer is prohibited from recovering some petition related filing fees. So we recommend that employers don't seek employee repayment of the base 460 H1B filing fee, the 1500 or 750 acquia fee, and the one-time $500 anti-fraud fee. And it's always best practice too. Now, the new fees of the asylum program fee of 300 for smaller employers and 600 for larger employers that the employer pays for those as well. For the premium processing fee, if the employee is requesting premium processing, then it's fine for the employee to cover that. However, if the employer is seeking premium processing for its benefit, for example, to avoid a gap in employment when the USCIS is taking too long to process the extensions, or if the employer wants to onboard the employee more quickly in an H-1B transfer context, then the employer cannot push those costs onto the employee. And then for attorney's fees, it may be possible to recoup a portion of that, but it can be complicated. It's subject to restrictions. So, for example, if the employee's payment of the attorney's fees would suppress the employee's wage below the prevailing wage, which is the required wage for an H-1B, then the employer can be in violation of Department of Labor's regulations. So, it's just the best practice is to not seek reimbursement of those legal fees either.
Right. We don't want employers getting into, a public access file audit and have issues if they have that payment. So good advice, Miki. And speaking of, I guess, celebration for whatever activities, we're going to, end here with wishing everyone a happy 4th of July. And we'll be taking a break next week, which is the week of 4th of July, and we'll be back the following week. So we hope everyone enjoys their Independence Day and has a wonderful time with friends and family.
So please join us 2 weeks from now for a discussion about avoiding perm that tests the labor market, since we spent some time talking about how long it takes and how difficult it is to do the perm. So we'll talk about potential ways to bypass that test of the labor market, including the national interest waiver.
Great. And if you all don't already, please follow the WR Immigration LinkedIn page as well as Miki and my profiles. And then we also transcribe this Rapid Fire Wednesday into a weekly newsletter that you can subscribe to. And this information to subscribe is in the comments. So until then, we are happy to have seen you and have a wonderful week.
Thanks, Kim.
All right. Take care, Miki.